Hello and welcome in our today's lecture of financial accountant, law for accountant. And today we will discuss learning outcome for understand areas of law affecting business and professional operations. So can you see my screen, Martin? Any issue? Can
Yes,
you hear my
it's
voice?
clear. Yes,
Okay.
very clearly.
So today uh, this is a assessment criteria. Basically, we will look at in our last lecture, which will be on next Saturday, 2 o'clock. So, but there are three main things we will discuss today. Main topic: data protection legislations, intellectual property, and employment law. Okay. So these are three main topics for our today's session. Indicative contents, as you can see here, data protection legislation, then intellectual property law, and then finally we will discuss employment law. So what is data protection? Any comments, Martin, or anything if you want to add?
Yeah, it's data protection. I think the way some companies collect information and use it in the past hasn't been very pleasant with the general public. So I think something was done about it to give it a bit of protection. I think this is what gave birth to
Yes.
data protection being taken, giving it a bit of support. Yeah.
Yes, that's correct. So basically, data protection is important in, safeguarding sensitive information stored by businesses, such as employee record and customer details. So from misuse by any, by unauthorized parties, uh, the Data Protection Act outlines key principles that must be adhered to when handling personal data. These principles include, if you look at here, uh, obtaining and processing data fairly and lawfully, using it only for specified purpose, ensuring it is accurate and kept up to date, and securely storing it to prevent unauthorized access or loss. Compliance with data protection regulations is essential to prevent fraudulent activities like uh, uh, phishing scams, and identity theft. If you remember, we discussed identity theft yesterday as well.
Yes.
I think so. You raised a question regarding mortgage, and I told you people use someone's mortgage fraud to someone identity.
Yeah.
Also, people, in mortgage fraud, people provide wrong information as well.
Okay.
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 Uh, Nowadays it is bit hard, but still people provide wrong kind of information. Let's say they provide wrong even price, okay, of
Mm.
house or purchasing price, or might be provide some fake documents or forged documents like that. It happened in in past. Okay,
Yeah. Mm.
still I think so. Obviously, you know that everything is digitalized, but thieves are digitalized as well. You know that they are very familiar with the new ways of fraud and other stuff or
Mm.
stuff.
So
So sorry.
I thought mortgage was the reason I asked that question was because I thought mortgage was is quite detailed the process, so probably there was not going to be a chance for anybody. But like your explanation did, there's still loopholes somewhere. So yeah.
Obviously, you know that still people provide wrong information. Okay, they they put wrong things on systems. Sometimes they check everything properly, but again, that everything can happen. Okay, so people provide wrong papers, forged, let's say, kind of stuff, use someone else's name. There are many things, that Martin, there are many things people do. So,
Okay.
you know, we are not completely out of fraud, any, frauds, corruptions, and bribery, as we discussed yesterday,
Mhm.
So things are everywhere around the globe. Okay.
That's right.
Like phishing scams and identity theft, which can have severe consequences for individuals and organizations alike. By following these principles, businesses can maintain the integrity and confidentiality of personal data, fostering trust with their stakeholders. Then key terminology, intellectual property. Any idea about intellectual property?
Uh, I think
It's a
that,
it's a very, very, important subject,
yeah,
not only in terms of accounting, but especially in terms of law, It's a very important subject.
yeah.
I don't know about like your country, or if I talk about Middle East or might some Asian country, but here and USA, it's a very important subject.
Yes, it is. I think when people copy your inventions or whatever work you've done and made use of it just to benefit their own interests, I think that's what I know,
Oh yeah,
intellectual
yeah.
property.
That,
So,
that's spot on. Yeah,
okay.
you're right. Intellectual property refers to creation of the mind, such as invention, artistic works or symbols that are protected by law. So it covers various form of protection, including copyright, patents, design, and trademarks. So these protections help creation prevent others from unauthorized use of a reproduction of their intellectual creations. So names of, if you see here, names of products or brands, inventions, design, and written work are examples of intellectual property that can be protected. But some form of protection are automatic. Others require formal applications. So intellectual rights are essential for creators to retain control over their creations and to receive recognition and financial reward for their innovation and creativity. So next is we are talking about employment law. Employment law includes regulations that governs the rights and responsibilities of individuals in the workplace. It covers various aspects of employment laws, including work time. Including here working conditions, wages like minimum wage, health and safety, equality, contract of employment, dismissals, uh, and redundancy. So employment laws ensures fair treatment and protection of employees, prohibiting discrimination based on factor like age, religion, or any sexual orientation. So these they also establish minimum standards for working conditions, such as providing health and safety equipment and ensuring fair pay. Uh, Analyze the requirement of data protection legislation. Data protection legislations outlines here six keys, you know, uh, six key principles that govern the handling of personal data. These principles serve to ensure that personal data is processed lawfully, fairly, and transparently. Consent from the data subject is fundamental requirements, including that individuals must give permission for their data to yeah. So put the data processed lawfully, fairly, data to be processed. So additionally, processing personal data must be necessary for a specific purpose, such as fulfilling contractual obligations or complying with legal requirements. Uh, Also, data processing should prioritize the protection of individuals' vital interests and adhere to public interest or official authority. Furthermore, data controls must consider legitimate interests pursued by themselves or third parties, ensuring that these interests do not override the rights and freedom of the data subjects. So, by adhering to these principles, organizations can ensure the responsible and ethical handling of personal data, fostering trust with individuals and compliance with legal obligations. Now is talking about personal data. Personal data is defined as any information about a living individual which is capable of identifying that individuals. So then a sensitive data, any information relating to an individual's racial or ethnic origin, political opinions, religion, religious belief, trade union memberships, physical or mental health or condition, sexual life, alleged or actual criminal activity, and criminal records. So, under GDRP, sensitive personal data is referred to as a special categories of personal data. So, distinction between personal data and sensitive personal data is important for organization to appropriately handle and protect individuals information. By recognizing the sensitivity of certain type of data, organization can implement appropriate security measures and ensure compliance with data protection regulations. What is data protection? Again, data protection is about avoiding harm to individuals by misusing or mismanaging their personal data. So by ensuring the responsible and lawful handling of their, personal data, organization uh, that collect, use, or store personal data are subject to data protection legislation, which sets out principle of guide their actions. These principles include collecting data only for specific purposes, ensuring data accuracy and security, and processing information lawfully. What is GDPR? So GDPR or Journal Data Protection Regulations. GDPR is a comprehensive set of data protection regulations that came into effect on May 25th, 2018. Replacing the Data Protection Act. GDPR introduces significant changes aimed at strengthening the right of individuals and imposing more obligations on organizations regarding the handling of personal data. To comply with GDPR, organizations must have a legitimate reason for processing data, ensuring that consent is freely given and easily withdrawn. Privacy considerations should be integrated into all data processing activities, following the principle of privacy of design and default. Additionally, organization must be prepared to respond to subject access requests promptly, providing comprehensive information about data processing and share activities. Uh, Individuals now have the right to request data deletion, known as the right to be forgotten under certain circumstances. So GDRP also mandates the reporting of data breaches and hold data processors accountable for compliance. Organizations must be able to demonstrate their compliance with GDRP regulations, and non-compliance can result in significant fines of up to 4% of annual global turnover or 20 million pounds. GDPR principles, lawfulness, fairness, and transparency, purpose limitations, only collect for specific purpose and then don't use it for other purpose, data minimizations, accuracy, storage limitations, integrity and confidentiality, and accountability. Data protection terminology, the understanding key terminology related to GDPR is essential for organization to navigate data protection regulations. Effective, uh, uh, effectively. So important terms include like data controller, uh, the entity responsible for determining how and why personal data is processed, then data subject, individuals about who personal data is being processed, data processor, uh, that a entity that process data, personal data on behalf of the data controller, processing any action performed on personal data, including its collection, storage, and use. Finally, data protection officer, a designated role responsible for ensuring compliance with data protection regulations, often required for large organizations. Can I still process personal data? Do I need consent? Okay. So GDRP and data DPA or Data Protection Act. The primary objective is to ensure that data processing and sharing are conducted appropriately rather than obstructing legitimate data activities. Consent may not always be required for processing personal data. If it fails under certain categories for necessity, for example, personal data can be processed without consent when it is essential for the performance of contract, like complying with legal requirements, protecting the vital interest of individuals of others, then pursuing legitimate interests that are not overridden by individuals' rights or freedom. So only when none of these criteria applies, explicit consent needed for data processing. Right. So next is explain how intellectual property can be protected. Uh, Obviously, IP or intellectual property refers to creations of mind, such as inventions, literacy, and artistic work and symbols, designs, and images used to commerce. So it's a safeguard by various legal mechanisms, including patents, copyrights, and trademarks, which grant individuals the right to benefit from their creation and invention. It is essential as it enables individuals and organizations to take legal action against those who unlawfully copy or imitate their works. So there are different type of IP protection, some of which are granted automatically, uh, and as you can see, it's granted automatically upon creation, while others require formal applications. So here, copyrights, automatic protections, copyrights, you can see TV, music, web content, sounds, shape of objectives, design rights. Then you have to apply type of protections, trademark, registered design, and patents. So product name, logos, jingles, type to allow for application 4 months. 1 month appearance of product, including shape, packaging, patterns, colors, decoration, and then patents, inventions, and products, for example, machines and machine parts, tools, and medicines, around 5 years. So how copyright protect your work? Uh, copy protection, copyright serves as a vital legal tool to safeguard your creative work and prevent unauthorized use by others. Importantly, copyright protection is granted automatically upon the creation of original work without the need of for in informal application or payment of fee. If we talk about UK, in the UK, there is no centralized registry for copyrights work. Uh, Upon creation, copyright protection applies to various types of original work, including literary, dramatic, musical, and artistic creation, as well as non-literary written works, sound recording, film broadcasting, and the layout of published editions. While marking your work with the copyright symbols, your name and the year of creation is optional. It does not impact the level of protection offered to your work. Uh, how copyright protects your work? Basically, scope of copyright protections grants your exclusive right over your work, preventing others from engaging in activities such as copyright, copying, distributing, renting, lending, performing, adopting, or sharing your work, publicity without your, permission. So this comprehensive protection extends to both physical and digital forms of your creations. Also, copyright protection may extend beyond national borders, copyright overseas, uh, through national borders, through international agreement like the Bern conventions. You can read in detail if you want to. So the duration of copy right varies depending on the copy of work, with most type of written, dramatic, and artistic work enjoying protection for 70 years after the author's death. While, while other forms of work have different copyright durations. Are you okay, Martin? Can you see my screen?
Yes, I
Yeah,
can.
it's okay.
Yeah,
Not
thank you.
getting bored.
Sorry.
I said not getting bored.
No, I'm enjoying it.
But basically, it's interesting. I think so that learning about data protection, copyright, and employment law, all three are very important and interesting topics.
Yes.
Yeah. So it's not. I think so. It's not directly linked to your practical work. Okay, but still, you can advise and you can talk about a few things.
Yeah, it's good when a client
Yeah,
brings
but
such cases to you.
like let's say uh,
Mm,
at least you will know about Data Protection Act, that you are familiar with, what you can disclose, how you can disclose, and why you can't disclose stuff like that. Then
that's right.
yeah, then also you will know about intellectual property law. uh, at least you can tell people that they can protect their creations, work, or stuff, inventions. And when you comes to the employment law, I think so employment law is a very important. Everybody must knows about at least basic employment laws. Okay. uh, as an employer and as an employee, you should know about your rights and limits within the law. Okay. So it will be easy for you to if you are asking things from your employees, or if you are giving warning or stuff like that, or even if you got issues with your employer. So you know that what law says, okay, regarding your issues.
Yes.
Uh, long copyright, how long copyright lasts? So the duration of copyrights begins immediately upon the creation of work, and typically lasts for specific periods determined by the type of work. One copyright expires, the work enters the public domain, so allowing anyone to use or copy it freely. So different type of work, the duration of copyrights, if you see here, written, dramatic, musical, and artistic work, 70 years after the author's death. Sound and music recording, 70 years after its first published. Film, 70 years after the death of the director, screenplay author, and composer. Broadcasts, 50 years from when it first broadcast. A layout of published edition of written, dramatic, or musical works, 25 years from its first published. Patenting your invention. Patenting your inventions, patents. You can use a patent to protect your invention. It gives you the right to take legal action against anyone who makes, uses, sells, or imports it without your permission. So, but obtaining a patent is a subject to certain criteria. Firstly, your invention must be capable of being made or used, meaning it should be practical and functional. Uh, in addition, it must be a new and inventive, demonstrating a significant advancement or innovation over existing solutions. So it's important to note that securing a patent can be both costly and complex, requiring through documentations and examinations, process. So basically, patents are expenses and are difficult to get. Right. What you cannot patent? You cannot patent certain type of inventions, including literary, dramatic, musical, or artistic works, way of doing business, playing a game, or thinking, a method of medical treatment, diagnosis, discovery, scientific theory, or mathematical method. Information is presented, some computer programs or mobile apps, essentially biological processes like crossing, breeding plants and plant or animal varieties. Protection of digital assets. Digital assets include various digital entities owned by individuals or organizations, such as photos here, such as photos, videos, and music files. Unlike tangible assets, digital assets have no physical form and exist as a file stored or electronic devices or cloud-based network. So, protecting these assets is vital, and several measures can enhance their security and integrity. Implementing two-factor authentications or 2FA add an extra layer of security to digital accounts, reducing the risk of unauthorized access. Managing rights and access ensures that only authorized individuals can manipulate or distribute digital assets. So, adhere to best practices for Wi-Fi security, minimize the risk of cyber attacks or data breaches. Additionally, obtaining suitable, insurance, get the right insurance. So, insurance coverage can mitigate financial losses in the event of digital assets theft or loss. So, by employing these strategies, individuals and businesses can safeguard their valuable digital assets effectively. Remedies for unlawful as of intellectual properties in cases where intellectual property rights are infringed upon. So private civil infringement actions include, uh, mm, if you see here, various remedies are available to the successful claimant in a private civil infringement action. So these remedies aim to rectify the harm caused by the infringement and provide compensation to the rightful owner of the intellectual property. Firstly, an injunction may be issued to prohibit uh, further unauthorized use of intellectual property. Additionally, the claimant may be rewarded costs incurred during the legal proceeding. Damages or an account or profit may also be awarded to compensate of financial losses resulting from the infringement. Furthermore, the court may order the delivery up or destructions of infringing items and any materials using to produce them. Others remedies include tracing orders and orders for the applications of a judgment. So these remedies serve to uphold the rights of, uh, you know, uh, intellectual property owners and deter future infringements. Some relevant question: why should I protect my intellectual property and carrying out intellectual property audit? So, why should I protect my intellectual property? Basically, understanding the importance of intellectual property is important for businesses seeking to safeguard their innovations and creations. Intellectual property play a significant role in the success of a business, particularly in preserving strong brands and maintaining a competitive edge. Protecting intellectual property assets through audits helps identify areas where protection is needed and assess the value of these assets within the organizations. Conducting an intellectual property audit enables businesses to secure their intellectual property rights effectively and mitigate the risk of infringement. Impact of intellectual property for businesses. Again, as we said, intellectual property, including patents, trademarks, and design rights, play a vital role in protecting the innovation and assets of businesses. So, patents offer exclusive, protection for inventions, allowing inventors to prevent authorized use by others. Trademarks protect unique aspects of a businesses, such as brand name and slogans, enhancing brand recognition and loyalty. Registering trademarks with the appropriate authorities strengthens legal protections and facilitates enforcement against infringers. Design rights provide automatic protection for the appearance of three-dimensional objects, while registered design offer broader and extended protection for both three-dimensional and two-dimensional objectives. So understanding and securing intellectual property rights are essential steps for businesses to safeguard their innovations, maintain competitions, and preserves their brand reputation. Uh, Intellectual property rights, including copyright, play an important role in protecting the creative and innovation works of businesses. Copyright protection is automatically granted to original literary or artistic creations such as website content, instructions, manuals, paintings, sound recording, and software. So without the need for formal application, uh, this protection safeguards the rights of creation and prevents authorized use or reproduction of their work. While copyright protection is automatic in the UK. It may require formal registration. It may require, formal registration in the other jurisdictions, such as the US. Uh, Understanding and securing intellectual property rights are essential for businesses to safeguard their valuable creation and maintain a competitive advantage in the global market. Assess the impact of legislation related to employment. Now we are coming to the employment law. So employment law plays an important role in regulating the relation between employers and employees, ensuring fairness and protecting the right of workers. It covers various aspects of the employment relationship, including recruitment processes, terms and conditions of employment, data protections, working hours, holidays, health and safety regulations, maternity and paternal rights, discriminations, grievance handling, dismissal process, employment tribunals, and redundancy. So compliance with employment law is essential for businesses to create a harmonious and legally compliant work environment, fostering positive employee relation and ensuring adherence to ethical and legal standards. Any comments about employment law? Any question or anything?
No, so far so good.
Okay, so employment and the law. If you see here, employment law sets minimum standards for workplace conditions and employee rights, ensuring fair treatment uh, and promoting workplace safety. It prohibits discrimination based on factors such as age, religion, or sexual orientations, and mandates equal pay for equal work regardless of gender. Law against unfair dismissal protect employees from arbitrary termination, while health and safety legislation mandates the provision of necessary equipment and training to ensure employees' well-being. Recruitment procedures must be fair and discriminatory, and employees have the right to written contracts outlines their terms of employment. Dismissal should only occur for valid reason, such as incompetence or gross misconduct, and employee have the right to appeal unfair dismissal decision to employment tribunal. Overall, employment law serves to uphold worker rights, promote equality, and established a framework for, fair and lawful employment practices within organizations, company, or business. Type of employment. There are two types of employment. There are two types of working relationships. Employees work under a contract of service. Independent contractors, self-employed, works under a contract for services. So there exist, in employment exist two primary type of working relationship: employees and self-employed. Employee works under a contract of service which establish a formal relationship between the individual and the employer. Under the arrangement, the employee is subject to the employer's directions and control, and the employer is responsible for providing work assignments, determining working hours, and providing necessary resources for the job. Uh, Employees also are entitled to certain rights and benefits, such as protection against unfair dismissal, redundancy payment, and minimum notice period for contract terminations. Employment Right Act 1996 and then Equal Pay Act 1970. 1966 Employment Rights Act is a significant piece of legislation that grants certain rights and protection to employees in the UK. Among its provisions, the Act ensures that employees have the right not to be unfairly dismissed from their employment. Uh, Providing recourse for individuals who believe they have been terminated unjustly. Additionally, the Act mandates redundancy payments for employees who are made redundant, offer financial support during periods of job loss. Also, the Act stipulates minimum notice periods that employer must provide to terminate an employment contracts, ensuring that employees are given reasonable time to prepare for the end of their employment. Uh, Also, Equality Act 1970 addresses issues of pay equally in the workplace. This legislation prohibits discrimination in pay and terms of employment based on genders, ensuring that individuals performing similar work receives equal compensations and benefits regardless of their gender. National minimum wage. This is, as I said, it's. I'm not talking about today's day 24. This is according to. This is an example. You understand, Martin?
Yes, I know these figures are not up to date.
Yes, it's not. But this is also an example or idea for, like,
Okay.
from uh, Act 9, Minimum Wage Act 1998 creates a minimum wage across the unit. So from 1st April 21, this was 890 for people age 23 and over, then 836 for 21 to 22, then 656 over 22 years, 18 to 22 years old, 20 years old, sorry, and then 462 for people under 18, and then 430 for apprentices or less, under 18. Statutory redundancy. Statutory redundancy pay is a form of compensation that employees are entitled to receive when they are made redundant from their job. So to qualify for statutory redundancy pay, an employee must have worked for their current employer for at least 2 years. The amount of redundancy pay is calculated based on the employee's length of service and their weekly pay. So employees are entitled to half week pay for each full year uh, they were under 22, or weeks pay for each full years they were age 22 or over but under 41, and 1.5 week pay for each full year they were 41 or older. So the length of service used to calculating redundancy pay is capped at 20 years, and the weekly pay is determined by averaging the employee's earnings over the 12 weeks before they received their redundancy notice. Statutory redundancy pay provides financial support to employees during period of job loss or helps them transition to new employment opportunity. Termination of employment contracts. Termination of of an employment contract, often referred to a dismissal, occurs when an employer ends the employment relationship with an employee, so typically due to the fault or conduct of the employee. In such cases, employees are required to provide notice to the employee before terminating their employment. So minimum period, notice period, if period of notice is not expressly agreed, and the Employment Rights Act 1960 1996 imposed the following minimum notice periods: 1 month to 2 years, 1 week notice; 2 to 12 years, 1 week per complete year. So it could be, if 12 years, so 12-week notice. So 12 years plus up to 12 weeks. So that's mean is 1 week notice for 1 month to 2 years, and then 1 week per, if under 12 years, it will be 1 week per complete year, and then 12 week if after 12 years, working over 12 years. So you are entitled to statutory redundancy pay if you are fall into one or more the following categories: former registered dock workers or share fishermen are covered by alternative arrangement and are not eligible for statutory redundancy pay. Crown servants, members of the armed force or police services are exempt from the statutory redundancy pay by entitlement. Applications who do not transitions to become employee upon completion of their transition training are not eligible for statutory redundancy pay. And then domestic servants who are immediate family members of their employers are also excluded from statutory redundancy pay entitlements. So these exclusions basically reflect unique employment circumstances where alternative arrangement or exemptions apply, rendering statutory redundancy pay unnecessary. Short-term and temporary layoff, uh, employees who have been temporarily laid off without pay or with less than a half a week pay may still be eligible for statutory redundancy pay under certain conditions. If an employee experienced temporary layoffs for more than 4 weeks, yeah, in a row, or more than 6 non-consecutive weeks within a 13 weeks period. So they can claim statutory redundancy pay. To initiate the claim process, the employee must inform their employer of their intention to claim within 4 weeks of their last non-working day in the specified period. If the employer does not reject the claim within 7 days, the employer can proceed with the claim by providing notice to their employer. But if the employee's normal work is expected to resume within 4 weeks and continue for at least 13 weeks, their claim may be rejected. Consultation. Employees facing redundancy are entitled to a consultation with their employer to discuss various aspects related to redundancies process. So the consultations involve uh, explaining the reason for the redundancy, also explaining any alternatives to redundancy. So the consultation process varies based on the number of redundancies being made by the employer. For fewer than 20 redundancy, there are no specific rules regarding the consultation process. But if 20 or more redundancies are being made, are being made, the collective redundancy rules apply. So the length of consultations period is not strictly defined, but there are minimum requirements. Like if you see here, right, up to 19, for 20 to 99 redundancy, the consultations must begin at least 30 days before any dismissal take effect. So for 100 or more redundancies, the consultation must begin at least 45 days before any dismissals take effect. So these consultations requirements aim to ensure that affected employees are informed about the redundancy process and have the opportunity to provide input or explore alternative situation where possible. Next, unfair, wrongful, and constructive dismissal, advisory, conciliation, and arbitration services, ACAS. So, ACAS plays a significant role. ACAS is an organization focused on improving employment relationships and resolving dispute between employers and employees. They work collaboratively with both parties to address issues and enhance workplace performance. Additionally, employment tribunal uh, serves as a legal avenue for resolving employment related disputes. ACAS code of practice, uh, the ACAS code of practice outlines guidelines for employers and employees to ensure a fair, consistent treatment in disciplinary and grievance procedures according to these codes. So employees should conduct through investigations to establish facts before making decisions. Employees should be informed of the issues and given the opportunity to present their case before any decisions are made. Employees should have the right to be accompanied by a representative during formal disciplinary or grievance meetings, and employers, normally union reps, you can say. So employers should provide employees with the option to appeal against any formal decisions made. So these are main principles. These principles aim to promote fairness, transparency, and procedure consistency in employment related matters. Unfair dismissal by an employer may be deemed unfair if certain conditions are not met. These conditions include having a valid reason for dismissal, following the company's formal disciplinary or dismissal process, or adhering to the statutory minimum dismissal procedures. A situation where dismissal is likely to be unfair include instances where the employees uh, requested a flexible working arrangement, refused to waive working time rights such as rest breaks, resigned with the correct notice period, engaged in trade union activities, participated in legal industrial action lasting 12 weeks or less, required time off for jury services, then applied for or was on maternity, paternity, or adoption leave, attempted to enforce the right to receive working tax credits, exposed wrongdoing in the workplace, whistleblowing, was subject to compulsory retirement. So these criteria serve to protect employees from unfair treatment and ensure that dismissal process are conducted in a lawful and equitable manner. Constructive dismissal, when employee is compelled to resign from their job due to their employer's unacceptable conduct. So the reason for leaving must be significant, such as non-payment of wages or sudden demonstrate. These are basically few examples. uh, or sudden demotion without justification. Yeah, without any proper justification. Imposition of unreasonable changes to work conditions, such as requiring night shift despite a day work contract, failure to address harassment or bullying by other employee. A breach of contract by the employer can stem from a single serious incident or a series of serious incidents. When considered together, it advisable to attempt to resolve any issues or communicating with the employer to address the a dispute. So, but if there is a case of constructive dismissal, it's recommended to resign immediately. This prevents the employer from arguing that continued employment implies acceptable of the unacceptable conduct or treatment. Equal opportunities legislations. The Equal Opportunities Act 2010, which came into effect in August 2011, aims to identify and eliminate discriminations, victimization, and sexual harassment in various contexts. So the legislation protects individuals based on specific characteristics, including these are also called protected, characteristics like age, disability, gender reassignment, marriage or civil partnership, uh, pregnancy and maternity, race, religion, or belief. Yeah, that's it for today. As already we discussed ACAS code of practice. So if you want to go, further detail, you can, read ACAS code of practice. So that's it
Okay.
for today, Martin.
Thank
If
you so
any
much.
issues, concerns, you can drop me an email at yasir@ukversity.co.uk. And that is for today. And I hope you enjoyed today's session. And it was really interesting for me, that every day we learn new things, especially, employment law is a very important topic.
Yeah.
So thank you very much, Martin. Uh, I'll see you next Saturday for our last session, which will be assignment discussion. Okay. So thanks. Any questions, Martin? Any concerns, any issues?
Other things where I don't know, I forgot to write the slide on remedies. I think that there's one slide on remedies.
Yeah, there is a slide on remedies.
Yeah. I wasn't too sure what remedies means. Probably I need to read.
Remedies mean solutions.
Oh, okay. Okay.
Okay. It's a legal term. Remedies
Okay.
basically it's a legal term. Like accountants use different words,
Yeah.
business, English or language. So remedies, basically it's a legal term they use as, remedies available for,
Like solving a problem, is that right?
yes, solutions.
Okay.
Okay. So what
Solution.
remedies available? Like you can go to the court, you can go to the court under section this, and these are remedies available under section 213. These are remedies available under section, criminal law under section this. These are remedies. Okay.
Okay.
Okay, when you read any books, it says what remedies are available. Remedies are available under section this, this remedies available under section this, section 196 employment law. These are remedies available for
Okay.
your situation. Okay.
Okay. Thank you very much.
Okay. Thanks, Martin. Thank you very
Thank
much.
you.
And I'll
I'll see
see
you
you
next week.
next Saturday
Yeah.
at 2 o'clock. Okay.
Thank
Thanks
you.
and bye for now. Okay.
Bye-bye.